Right, good morning everyone and welcome. My name is Karen Wallace and I'm one of the senior consultants here at Newground. So I'm going to be your host for this environmental legal update webinar. It's been over 12 months now since we last held our webinar, so there is plenty to fill you in on in this session. But first things first, let me just say a few words about the software. So we're using Zoom software for this webinar. Now we've held quite a few webinars using this software now, so hopefully there won't be any issues. Please do let us know if you are having trouble viewing the screen or hearing me though. Zoom automatically mutes any microphone or webcams that you've got on the device that you're using to access this webinar. That means that you can't ask me questions verbally because I won't be able to hear you. But it also means that you don't need to worry about any sound or anything happening at your end interfering with the webinar. Neither I nor anybody else attending the webinar are going to be able to see or hear any of the other delegates. However, there is a facility for asking questions that you may have as we go through the session. You will be able to see at the bottom of your screen a tab which says Q&A. So if you click on that, you can type a question and submit that to us. And if you do choose to submit a question, you do have the option of sending it anonymously, which means no one will be able to see the name of the person who has asked the question. Please do use the Q&A panel as opposed to the chat function, as we're not monitoring the chat function this morning. We will endeavour to answer all questions that we receive. Any questions that we can't answer during the session due to the time or because it was a particularly detailed or complex question, we will respond to everybody individually after the session. And please don't feel like you have to make copious amounts of notes, as we are going to be sending a link after the webinar, which will allow you to download the slides and include a recording of the session. You will also receive an anonymised copy of all of the questions received during the webinar and our answers to those questions. Okay, so now we've got housekeeping out of the way. Let's go on to what the webinar agenda is. I'm going to be looking at changes in environmental legislation over the last 12 months, and I'm going to be talking about new legislation that's come into force, significant changes to existing legislation, and also consultations that concern potential changes to legislation, which is the stuff that we include on LUS under the On the Horizon section. What I'm not going to be covering is legislation relating to Brexit, which obviously continues to be an area of significant uncertainty at the moment. If and when we do leave the EU, we will of course inform you on what changes you can expect to see. Okay then, let's get started. So I'm going to go through the changes by chapter, just as it's set out in LUS. And first up, we're going to cover pollution legislation. So before I talk about what's new here, I just wanted to mention the little flags that you can see on the right-hand side of the screen next to the legislation title. You'll see those on all of the slides where I'm talking about something that's new or amended. And they're just a quick reference for you as to what jurisdiction that particular piece of law I'm talking about applies to. So you can see there that the permitting regs that I'm about to talk about, they're applicable to England and Wales only, which is obviously already suggested by the title of the legislation. So let's go back to what's new, and I'm going to talk about the environmental permitting regs first of all. I realise that these aren't new, and they came into force on the 1st of Jan 2017, and I did speak about them at last year's webinar. But I thought one of the changes was worth mentioning again because there's more information available on it now, and it is going to be relevant to a lot of organisations, I think. So the change that I wanted to re-emphasise is that of the Medium Combustion Plant Directive being transposed into the permitting regs. So a medium combustion plant is defined as a combustion plant or a combination of combustion plants with a thermal rated input equal to or greater than 1 megawatt, but less than 50 megawatts. So again, that's megawatts of thermal input, not electrical output. So for ease, while I'm talking about this, I'm going to be referring to medium combustion plants as MCP. If you have an existing MCP within that range, or you're planning to install one, you need to be aware that the permitting regulations now include permitting requirements for the operation of MCPs. And this is in order to regulate emissions specifically around air quality. There are certain deadlines for when the requirement for a permit kicks in. So you can see those on the slide there, and it's dependent on whether it's a new or an existing plant. So new MCPs are those that have been put into operation since the 20th of December 2018, and existing MCPs are defined as plant that was brought into operation before the 20th of December 2018. There will be standard permits for simple low-risk MCPs, but those that have been identified in a local authority air quality management area, or ACMA as you might know it, they could require a bespoke permit. So it's best to contact your regulator to find out what you need to do if that's the case. MCPs are going to have to comply with emission limit values for sulfur dioxide, nitrogen oxides and dust, subject to specific exceptions. And the permit conditions will also require that emissions are tested periodically to demonstrate that they're compliant with those relevant emission limit levels. And in addition to that, MCP operators were going to have to keep a record of operations to demonstrate compliance with their permit conditions for at least 6 years. Now, some generators are going to be exempt from these permitting requirements. Emergency backup generators, so those that are being used for the sole purpose of supplying power during an on-site emergency, like a power cut, they're exempt when they're being operated for the purpose of testing, as long as the testing is for no more than 50 hours per year. And it's worth noting at this point that operating a backup generator to provide power during an emergency is unrestricted. So the 50 hours limit should be adequate for most companies, but if you do need more than 50 hours of testing in a year, then that has to be agreed with the regulator in writing. And it's also worth saying at this point, I think, that the guidance that I've read says that operators should maintain records of annual hours of testing for each individual generator to ensure that the exclusion criteria can be demonstrated, i.e. that you are under that 50-hour limit. In terms of other exemptions, there's one for generators operating at a site that is subject to a nuclear site licence, and also one for generators that are being operated offshore as well. It's important to point out that generators under the 1 megawatt thermal input threshold that have a capacity market agreement, or they're providing a balancing service or a demand side response, they're not exempt because that's not classed as an on-site emergency. What I mean by those is generators that are generating for their own purposes or to help the national grid manage supply and demand. Also, if you're involved in something called triad avoidance, which involves reducing demand by generating electricity using backup emergency generators instead, that's not exempt either, regardless of hours of operation. Generators below that 1 megawatt thermal input threshold are also not exempt if they form part of something called a specified generator, where the generator, the combination of the generators has a total rated thermal input of more than that 1 megawatt up to the 50 megawatt threshold. And then one potential new exemption is for R&D testing activities, because DEFRA's just finished a consultation which proposes an amendment to these regs to exclude R&D testing activities. So that might end up being another eligible exemption as well. So what does all of this mean for you then? If you're in the process of planning to install a new combustion plant within that 1 to 50 megawatt thermal input threshold, then you do need to be considering how you're going to comply with these regulations. And if you're currently installing an MCP and you've not yet applied for a permit, then you need to do so quickly, because it can take the agency and the National Resources Body for Wales significant time to process, review and grant permits. Guidance that I've read suggests that you should be applying at least 12 weeks before that plant is due to start operating to make sure that the permit is in place in time. And just, I want to mention mobile generators before we move on from these regs. By mobile, I mean a generator that is designed to move or be moved, whether that's on the roads or on land. Mobile generators don't fall within the definition of generator under these regulations, with 2 exceptions. Firstly, if they're connected to an electricity transmission system or a distribution system, or secondly, if they are connected to other apparatus, equipment, or appliances at a site and they're performing a function that could be performed by a generator that isn't mobile. If a mobile generator isn't connected to the grid, but it is connected to other apparatus, equipment, appliances on site, for instance, the regulator has to consider whether the function that that mobile generator is carrying out could be performed by a static generator instead. And again, from current guidance that I've read, it says that a mobile generator that's in place for 6 months or more will be considered in scope of these regulations. So something to consider there. Okay, next up we have the Environmental Authorisations Scotland regulations. They aim to deliver an integrated authorisation framework to integrate as far as possible the authorisation, procedural and enforcement arrangements relating to 4 areas, which are water, waste management, radioactive substances and pollution prevention and control. Because this framework is being developed in a phased manner, the regs at the moment only apply to radioactive substance activities. What they do is prohibit activities involving radioactive material and or radioactive waste from being carried out without an authorisation. And in Scotland, there are 4 types of authorisation available. You have general binding rules, notifications, registrations and permits. And the level of complexity and risk associated with an activity determines the type of authorisation you need to apply for from SEPA. If authorisation is granted, then that authorised person must ensure that the regulated activity is carried out in accordance with that authorisation. Now, there are a number of activities which aren't classed as radioactive substance activities within the regs. Therefore, they're not in scope and you don't need authorisation. So I've listed those for you there. So I'm just going to give you a moment to read through those. Okay, now let's go on to the Environmental Protection Miscellaneous Amendments England and Wales Regs 2018. These close a loophole within environmental permits for waste activities. So waste permits that have been issued since the 6th of April 2008 include a condition that says that a site must produce and review a written management system. This amendment applies to those permits that were issued before that date where that condition was missing. And this is to ensure that all permitted sites are required to produce and review a management system, which is hoped will contribute to better management and improve performance at those permitted waste sites. When it says written management system, what it means is a document or documents that identify and minimise the risks of pollution arising from the site's operations, which include but aren't restricted to risks of pollution from operations, including maintenance activities, an accident, failure to comply with the permit, a complaint, or perhaps closure of the operation. That management system has to be reviewed and kept up to date, and the operator must keep a written record of activities under the management system and of any reviews or updates made to the system. It's also now compulsory for an operator of an environmental permit for waste activities to demonstrate their compliance with a suitable accredited scheme to the regulator. These accreditation schemes require operators to gain either a primary qualification or an environmental permitting operator's certificate, or EPOC. Depends on the risk level. And then they need to pass a continuing competence assessment every 2 years to demonstrate that their technical competence is being kept up to date. So the 2 schemes there are shown on the slide, and you might already be familiar with them. To be clear, the compliance schemes themselves aren't new, it's the requirement to comply with them that is. And if an operator doesn't comply with one of the above schemes, then they must include this within their waste return to the regulator. Okay, so that's it for pollution. Now we're going to head on to energy law, and there's lots of changes here that I want to mention. As you'll know if you were a participant in the CRC scheme, the final phase, which began in 2014, ended on the 31st of March this year. And the CRC Energy Efficiency Scheme Revocation and Savings Order 2018, that made the provisions for that early closure of the scheme. Participants who qualified for that 2014-2019 final phase, or for the previous phase, which ran from 2010 to 2014, they're still required to comply with their obligations as usual. For the final phase, participants were required to monitor their supplies of electricity and gas from the 1st of April 2014 to the 31st of March 2019, and to purchase and surrender sufficient allowances to cover the related emissions. The surrender for the final year is due by the last working day of October of this year. The Environment Agency is required to maintain the CRC register until the end of March 2022, and that's the place where participants submit their annual reports, where they order, buy, surrender and transfer allowances, as well as provide contact and organisational structural details. After that date, the agency must close the accounts and isn't required to maintain the registry. However, it is required to store that information that was contained within the registry and to maintain a list of participants until the end of March 2025 in order to facilitate any outstanding activities that are related to that final phase. The agency is also going to have continue to have powers to monitor and enforce compliance by participants who qualified for either that final phase or the previous phase. And they have those until the end of February 2022. So they're still going to be able to impose a penalty for requiring the purchase and surrender of additional allowances. They're also still going to be able to impose the penalty of blocking access to the registry or of publication of a participant's details on the registry until the end of March 2022, when the registry closes. It's important to note that if you're a participant who qualified for the final phase, you're also required to inform the administrator about a change of address until the 1st of April 2025, and you do still need to maintain your records until the end of March 2025 as well. Next up, we have the Energy Efficiency Private Rented Property England and Wales Amendment Regs 2019. And it's important to stress that the amendments are only relevant to domestic properties here. So this amendment means that landlords are now required to fund up to £3,500, including VAT, for energy efficiency improvements to ensure that their property meets the minimum requirements of an energy performance certificate rating of E or above. This removes the previous no cost to landlords provision, as it was called, even where they can obtain third-party funding, which might be a local authority grant or a Green Deal finance agreement, for instance. However, there is a spending cap of £3,500 placed on the landlord for those improvements, and that £3,500 includes VAT and any third-party funding obtained. So it means that the landlord isn't duty-bound to spend more than the £3,500 on improvements. Where there is third-party funding available to fully cover the costs of improvements, there is no spending cap. If previous energy efficiency improvements have been made on or after the 1st of October 2017, the landlord is able to subtract any costs of those improvements from their spending cap. So for instance, if a landlord spent £800 including VAT on improvements in December 2017, but the property still doesn't meet an EPC rating of E or above, then the landlord must make further improvements to that property up to a value of £2,700 including VAT. Or they have to prove that they are eligible for an exemption. So there are high cost exemptions available where the property, where the improvements required to meet an EPC rating of E or above for a domestic private rented property would cost over that £3,500. But in order to obtain the exemption, the landlord has to submit 3 different quotes from installers, which shows that the costs exceed that spending cap. A previous exemption which exempted landlords from the requirement to improve their property because a tenant hadn't consented to a Green Deal finance charge being added to their energy bills, that's no longer available. Instead, the landlord has to now consider alternative funding. And another exemption that was previously available was the no third-party finance exemption. So previously, a landlord that wasn't able to secure third-party finance for improvements, they were then exempt from that requirement for 5 years. That exemption is no longer available, and any exemptions registered on or after the 1st of October 2017 are now going to expire on the 1st of April 2020. So it gives a bit of time for those with the exemption to comply. Next, we have the Renewable Heat Incentive Scheme Regulations 2018. If you're not familiar with the Renewable Heat Incentive, it's a scheme to encourage renewable generation of heat by giving subsidy payments to eligible generators. And these 2018 regulations replace the previous 2011 regs of the same name. They have very similar requirements, but there are a number of amendments to things like the scheme's eligibility criteria, methods for calculating and issuing payments, budget control mechanisms, powers to impose sanctions if you don't comply with the scheme, and also the levels of tariffs for making payments to participants. There's also changes to the registration process to be aware of. So for instance, if you make an application to become a participant within the scheme, you now have to make a declaration that the necessary environmental permits have either been granted or that you don't need those permits. And the declaration also has to confirm that the plant and its operation comply with all relevant environmental legislation. And for biomethane producers that are registering to use a scheme, they need to specify the biogas production plant that they're going to be using to make the biomethane. And they need to confirm that the equipment used to produce the biomethane has been commissioned. Biomethane producers are only going to be able to register one biogas production plant for the scheme, and that's in order to remove the risk of biogas produced at a single site being used for multiple registrations. There's now also an annual requirement that new participants producing biogas from anaerobic digestion, either from combustion, or for conversion to biomethane and injection into the gas grid, they must produce at least 50% of their biogas from waste or residue in order for all the biogas produced or biomethane injected to be eligible for subsidy support. With regards to data submissions, participants are able to submit estimated data to the Gas and Electricity Markets Authority in order to claim their payments, but this is only for exceptional circumstances where meter readings can't be provided. There is a limit now of no more than 8 estimated data submissions over the 20-year tariff lifetime, and you won't be able to submit estimated data if it's going to lead to a revision of payments that have already been made. Okay, with regards to tariffs, there is a tariff guarantees process in place now, and that's designed to give applicants greater certainty at the early stages of planning a renewable heat project about the tariff that they will be eligible to receive in respect of either renewable heat or biomethane production. Tariffs for biomethane production are going to be reset to the levels available between April and June of 2016. And tariffs for biogas combustion systems will be reset to the levels available between October and December 2016. Participants whose plant breaks down, they're now able to replace it and stay on the same tariff for the remainder of their participation in the scheme. However, the replacement plant should be a new like-for-like replacement, where like-for-like refers to the technology type and the capacity. Replacement plant should be able to maintain that original tariff for any capacity up to that of the original plant. But for any capacity beyond that of the original scheme accreditation, you won't be eligible to receive support payments. And one last thing to note on this one, there are some heat uses that were previously eligible for the scheme that are no longer eligible. And those are heat that's used to dry digestate, which is a byproduct of anaerobic digestion that can be used for agriculture, and also the drying of wood fuel, unless in certain specified circumstances. Now to the Alternative Fuels Infrastructure Regs 2018, and these only apply in the Republic of Ireland. The UK's version of the same name were published in 2017, and we covered those in last year's webinar. So the aim of these Republic of Ireland regulations is quite similar to the UK's version. It's to increase the use of alternatively fueled vehicles and environmentally beneficial practices of using electricity to power berthed seagoing ships. They cover technical specification and customer experience standards for electrical vehicle recharging points and for hydrogen vehicle refueling points. They also cover technical specification standards for shoreside electricity supply points for ships. The main requirement really is that recharging and refueling points must be available for use by the general public, and they must also be compliant with the relevant technical specification standard. And note that it is the infrastructure operator of the recharging or refueling point that is responsible for compliance, whether they own the asset or they're working on behalf of a third party. So for example, a statutory harbour authority that was operating a shoreside electrical installation for those seagoing ships. Now we're going to move on to the Companies, Directors Report and Limited Liability Partnerships, Energy and Carbon Report Regulations 2018. Long-winded title there. This brings in the Streamlined Energy and Carbon Reporting Framework, which also is known as SECR. And the UK government has brought this reporting framework into play following that the CRC scheme that I mentioned earlier being abolished in the end of March, although it is going to apply to many more businesses than were captured by CRC. SECR came into force on the 1st of April this year, and for any businesses in scope, compliance will be for financial years starting on or after the 1st of April of this year. Note that it doesn't replace existing requirements such as e-source, climate change agreements and the EU emissions trading scheme. What it does do is extend the existing reporting requirements for quoted companies, and it does bring in new requirements for annual disclosures for large unquoted companies and for limited liability partnerships. So there are three groups of businesses that are affected by these regs, and the reporting requirements are different depending on which type of business you are. If your company falls within these following definitions, then you must comply unless you meet certain exemption criteria. So firstly, if you are a quoted company of any size that is already obliged to report under mandatory greenhouse gas reporting regs. Secondly, if you're an unquoted company incorporated in the UK that meets the definition of large under the Companies Act of 2006, and that applies to registered and unregistered companies. And thirdly, large limited liability partnerships. So unquoted companies and LLPs are defined as large if they meet at least two of the following three criteria in a reporting year. So firstly, a turnover of 36 million or more, or a balance sheet of 18 million or more, and 250 employees or more. Public bodies don't fall under these regs, but they are subject to other legislation that equally requires carbon reporting. There is also a statutory de minimis exemption for quoted or large unquoted companies and LLPs if they can confirm that their energy use is low. And by that, it has to be 40,000 kilowatt hours or less over the reporting period. Those companies still need to include a statement within their directors' reports confirming that they are a low energy user. If preparing a group report, that low energy user threshold applies to the energy consumption of the parent group and its subsidiaries. In terms of what's required, quoted companies have to make statements in their director's report concerning their energy use from activities for which they're responsible and from purchases for their own use, as well as action taken to increase their energy efficiency and any savings made as a result of those actions. Large unquoted companies must make statements in the director's report concerning their greenhouse gas emissions, plus their energy use and action taken to increase energy efficiency, again, as well as savings made as a result of those actions. If activities consist wholly or mainly of offshore activities, then the company must also include certain activities in the offshore area as well. Now, there is a comply or explain clause which allows carbon and energy information to be excluded where it is not practical to obtain it, or in exceptional circumstances where the disclosure would be seriously prejudicial to the interest of the organisation. With regards to groups and subsidiaries, if a group level report is required, it should include energy and carbon information for both the parent group and any subsidiaries. But there is an option to exclude energy and carbon information from the group report if it relates to a subsidiary that would not be obligated to report under SECR within its own right. If a UK subsidiary is required to report under SECR, then it might not need to include the energy and carbon information within its own subsidiary accounts and reports if those obligations are already met through the parent group report. Okay, with regards to LLPs, they will be required to prepare and file something called an energy and carbon report rather than the director's report information. And that report must include statements concerning the LLP's greenhouse gas emissions, energy use, action taken to increase energy efficiency, and savings made, just in the same way that you have to do for the unquoted companies. And the requirements related to groups and subsidiaries are the same as I've just been through for quoted and non-quoted companies. Quick mention of ESOS. So the Energy Savings Opportunity Scheme regs of 2014 haven't been amended, and I'm not going to talk about compliance with ESOS requirements here. What I did want to do is just quickly mention that the government guidance on how to comply with ESOS has been updated and also clarified relating to how to comply with phase 2. So it might be worth a look if you are obligated under ESOS. And also just a gentle reminder that the deadline for compliance with phase 2 is the 5th of December this year. So if you haven't already taken action on that, it's worth making some progress with that one now. And that wraps up the energy section. So I appreciate there was quite a lot there to go through. Let's move on to changes in water legislation where things are much briefer. The one that I want to mention here is the Sustainable Drainage Approval and Adoption Wales Order 2018, which implements Schedule 3 of the Flood and Water Management Act of 2010, covering sustainable drainage. So Schedule 3 requires inclusion of sustainable drainage, or SUDs as they're known, for surface water in developments with drainage implications. And sustainable drainage basically means managing rainwater to, for instance, reduce damage from flooding and to improve water quality. So the implementation of Schedule 3 means that from the 7th of January this year, all new developments of more than one house, or where the construction area is 100 metres squared or more, they've needed to have sustainable drainage to manage on-site surface water. And the automatic right to connect surface water drainage systems requiring approval under Schedule 3 to public sewers, that's been removed. Instead, local authorities are given powers as sustainable drainage system approving bodies, known as SABs, to approve new drainage systems and their connection to public sewers. So a SAB's approval will be required before the construction of drainage systems can commence on new and redeveloped sites. Provided that appropriate national sustainable drainage standards are met, the SAB will be required to adopt and maintain the approved SUDs that serve more than one property. Transitional provisions have been included so that after Schedule 3 came into force of January this year, SAB approval will not be required for the following. So new developments that were granted or deemed to have been granted planning permission before the 7th of January, and new developments that submitted a valid application for planning permission before the 7th of January, but a determination by the local planning authority hadn't yet been made. There are also exemptions included within the order so that SAB approval is not required in certain instances. I've listed those on the slide there, so I'll just give you a moment to read through those. Okay, we're now going to go on to waste law, and there's a lot to talk about here. Firstly, Packaging Directive. So this 2018 European Directive, which amends the original 1994 Packaging Waste Directive, sets out duties for member states rather than ordinary businesses. But it's worth me putting in here because the way in which the government is going to discharge these duties is likely to be through amendments to existing packaging legislation or by introducing new legislation, which will obviously ultimately place duties on relevant businesses. This directive makes amendments to that previous packaging directive to require member states to implement measures to encourage two things. So one, the increase in reusable packaging that's placed on the market, and two, to reuse packaging where possible. The definition of packaging waste has been replaced, and there are also new definitions for reusable packaging and composite packaging as well. And there are some new packaging recovery and recycling targets for member states to achieve. So you can see there on the slide that there is a minimum 65% by weight target for all packaging waste recycled by no later than the 31st of December 2025, and that increases to 70% by the 31st of December 2030. There are also minimum targets by weight for specific materials contained in packaging waste too. And again, I've included those there on that slide, so I'm just going to give you a minute to look over those. Okay, let's move on to waste. So the Waste Electrical and Electronic Equipment Amendment number 2 regs that came out in 2018. They amend the 2013 WE regs to implement this open scope principle that you might have heard of. It means that if you're obligated, the number of WE categories that you report into remains the same, because in the UK we chose to retain the 14 categories of WE. But all electrical and electronic equipment products are now assumed to be in scope unless they fall under a specific exemption or exclusion. WE producer compliance schemes are now required to be a member of something called the PCS balancing system. And this is to ensure that costs of collecting WE, when requested to do so by local authorities, those costs are shared amongst all producer compliance schemes in the UK on a market share basis. And approved authorised treatment facilities for WE now have to submit their reports in the format published by the appropriate regulator, whether that's the Environment Agency, SEPA or National Resources Body for Wales, or online. This is to ensure that when the reporting format is updated by any of those regulators, the AATFs will be obligated to adhere to the new format. This amendment also clarifies that producer compliance scheme members pay charges according to the regulator in the UK nation where their head office is based. Or if they don't have a head office, then where their principal place of business is. So for instance, if a business has its head office in Scotland, then it will be paying the charges set by SEPA. And this has been done because the Environment Agency has implemented higher charges on businesses in England than those in Scotland via SEPA or those in Wales via the NRW. Now we move on to the restriction of use of certain hazardous substances in electrical and electronic equipment amendment regs 2019, so ROSH. They amend the 2012 regs of the same name, and those 2012 regs and these amendment regs implement the 2011 version of the ROSH Directive, which imposed harmonised restrictions on the use of certain listed hazardous substances in 11 categories of electrical and electronic equipment. Those categories include things like large household appliances, IT and telecommunications equipment, toys, leisure and sports equipment, and also a catch-all category for all other E not covered by any of those categories. Things like e-cigarettes, for instance. So to ease in the phasing of this additional E that was introduced into ROSH in 2011 through the open scope principle, there's been a transitional arrangement which ends on the 22nd of July, so not too far away now, for any E that had been previously outside of the scope of the original 2012 directive. So the phase-in transition or exclusion has allowed new in-scope E to continue to be placed and circulated on the EU market until the 22nd of July, even if they've contained those restricted substances. However, since that 2011 directive was published, there have been some unintended negative impacts on the secondary E markets, which have been identified as not in keeping with the aim of extending the lifetime of electrical and electrical equipment via repairs, resale and refurbishment. So with that in mind, these 2019 regs amend some of the requirements in the 2012 regs. So that means, firstly, that the restriction on the second-hand sale of electrical equipment that was compliant with the regulations before the 22nd of July 2019 is lifted, because otherwise recycling would be being promoted above reuse and refurbishment, and that contradicts the waste hierarchy. And secondly, equipment within scope of the directive can continue to be repaired and upgraded with new cables and spare parts after the 22nd of July deadline. It also means that musical pipe organs are now excluded, as the rules that had brought in an inadvertent ban on new pipe organs being sold within the EU due to the amount of lead being required to produce the pipes, which then prevented compliance. And lastly, cord-connected non-road mobile machinery, such as professional cleaning machines, that is to be treated in the same way as non-road mobile machinery powered by a battery or an onboard power supply, which was already exempted. Okay, next we have the Statistics, Waste Generation and Treatment Survey Order 2019. Again, only applies in the Republic of Ireland. In the Republic of Ireland, the Central Statistics Office conducts a biannual waste generation survey to collect information on the amount and type of waste generated by Irish businesses. That's data that in the UK we can obtain from waste transfer notes instead. This order requires all businesses with 10 or more employees and all those that contribute significantly to waste generation to submit data on their 2018 wastes. This data then gets used to compile national statistics on the amount of waste generated both by industry and also by type of waste. The data submission has to include certain information on each type of waste that a business generated in 2018. So I've listed those on the slide for you there. Again, I'll just give you a moment to read through those. Okay. Next, we move on to the Waste Fees and Charges Amendment Regulations. These only apply in Northern Ireland. And they just make amendments to the fees and charges for waste management licenses to ensure that they cover the costs of regulating waste activities by Northern Ireland's regulator, which is the Department of Agriculture, Environment and Rural Affairs. And that's done by implementing the 2019 Waste Management Charging Scheme, which increases the cost of applications to register as either a waste carrier, a broker, or a dealer. And as you can see from the slide, those monetary increases are actually quite minimal, but it's just to be aware that they have gone up. Next, we're moving on to air law, and there isn't really much to mention here. I'm just going to talk about the non-road mobile machinery type approval and emission of gaseous and particulate pollutants regulations 2018. They're going to be relevant to anyone manufacturing, importing or distributing non-road mobile machinery. When I say non-road mobile machinery, this means any mobile machine, item of transportable industrial equipment or vehicle with or without bodywork that is not intended for carrying passengers or goods on the road and is installed with a combustion engine. That's things like hedge trimmers, handheld chainsaws, bulldozers, generators, industrial trucks, forklifts, mobile cranes, for example. And these regulations revoke the previous 1999 regs of the same name, and they also introduce offences and penalties for engine manufacturers who either don't ensure that the engines being placed on the market for use in non-road mobile machinery are type approved, to demonstrate that those engines conform with air pollutant emission limits, or those manufacturers who fit defeat strategies to engines so that they can pass type approval tests. And this applies to all new non-road mobile machinery engines placed on the market from January of this year. Okay, a nice short section there on air and an equally short section on planning law coming up. Just one law to mention here, which is the Felling Scotland Regulations 2019, which obviously apply only in Scotland, and they set out the system for managing tree felling in Scotland, which is something that's required by the Forestry and Land Management Scotland Act of 2018. And tree felling includes coppicing, thinning out, also removal of trees. And that 2018 Act makes it an offence to fell a tree unless authorised by Scottish Forestry. So these regulations set out how you apply for felling permission so that you can be authorised to carry out felling if you need to. The regulations outline what information is required in an application and also the process for approving and rejecting applications. If Scottish Forestry does approve an application, then it can impose conditions on that permission if it wishes to. If it rejects an application, then you're not allowed to make another application for the same circumstance. Scottish Forestry has the power to instruct a landowner to fell trees through something called a felling direction. So if it thinks, for example, that removing trees would improve tree growth or prevent or reduce harm caused by those trees, it can issue this felling direction. Felling directions can't be given for trees in exempted spaces such as orchards, gardens, public open spaces or churchyards. Scottish Forestry can also give out something called a restocking direction. And this can happen, for instance, where a person's felled a tree with a felling permission or another authorisation. It could be where a tree that is not exempt has been felled, or it could be that the condition of a felling permission wasn't complied with. And restocking directions will detail how many trees must be planted, and they may also specify the species of the trees that must be planted and percentages of different types of trees if there's more than one species involved. They will also give a deadline date for that restocking to be completed by. Okay, that ends the part of the webinar that covers all of the new and amended legislation that you might need to be aware of. Now I'm just going to have a quick look at what's on the horizon, as we call it in LUS, which just means the things that are in consultation stage at the moment. There's just one consultation that I want to draw your attention to in this section, and it's this one called The Future of UK Carbon Pricing. The UK government and the devolved administrations in Scotland, Wales and Northern Ireland are currently seeking views on the approach the UK should take to carbon pricing once we leave the EU. There is a joint consultation out that asks questions with regards to either a standalone UK emissions trading scheme or to perhaps a tax on carbon. And it's split into 4 chapters. So chapter 1 looks at the proposals for having a linked or a standalone UK emissions trading scheme. Chapter 2 looks at proposals for the processes that would need to be involved in operating a UK emissions trading scheme. Chapter 3 covers proposals on the design and operational elements that are specific to the aviation sector. And Chapter 4 looks at how the UK proposes to fulfil its legal obligations as a current member of the EU emissions trading scheme with regards to phase 4 of that scheme. And also on how to potentially legislate for future improvements to the implementation of the EU emissions trading scheme in the UK. So this consultation is going to be of interest to individual companies obligated under the current European emissions trading scheme, as well as any representatives of the industrial power and aviation sectors that have got obligations under that scheme. The consultation ends on the 12th of July, so you don't have a lot of time to respond if you do intend to and you haven't done already. Okay, so we've come to the end of the session. I hope you found it useful. If you have any questions that you've not been able to answer during the session, or if you require any further information, then you can just get in touch via the number or email address shown on the screen. We would be extremely grateful if you could provide us with feedback on this webinar. You're going to be provided with a link to a feedback survey, and it would be greatly appreciated if you could complete this for us. Remember that we are going to be sending a link to download a recording of the webinar and the slides after this session, as well as an anonymised copy of all of the questions and answers received during the session. So all that's left to say is thank you for attending, and we hope to see you at another event soon. We are going to be keeping the session open for the next 15 minutes, so if you want to post any further questions, then you have a chance to do so now. Thank you.